Good afternoon, and thank you for joining us. I'm Robert Baylor, Director of Communications at NUCA. Welcome to our latest construction law webinar presented by NUCA's Legal Committee. First, before we begin, some webinar housekeeping for attendees. Today's webinar will be recorded. It will be available on NUCA's YouTube channel, which can be accessed via nuca.com. All participants are muted upon entry. Phone participants can use *6 to mute and unmute themselves. Questions will be asked at the end of the presentation. To ask a question, you can submit a written question at any time using the chat feature, and I will read them at the conclusion of our discussion. Now let's get started. Today's construction law webinar will discuss 10 challenges and pitfalls in differing site conditions. From claiming contractors should have discovered site condition to engineers not understanding subgrade issues, our two erudite attorneys will examine the top 10 allegations evoked against contractors facing differing site condition claims. Tom Olson and Shawn Farrell are well known to NUCA members as voices of authority on construction law. Tom is chairman of the NUCA Legal Committee and practices law in Minnesota as founding partner of Olson Construction Law PC. Shawn provides legal counsel to NUCA of New Jersey and is a partner in Cohen Seglius PC in Philadelphia, Pennsylvania. Thank you all for joining us today for our construction law webinar. Tom, I turn the webinar over to you.
And actually, I'm going to turn it over to Shawn as he's going to lead with the first topic today.
Yeah, we have a lot to cover here. Thanks, Tom. I appreciate always doing these seminars with you, and thanks, Bob from NUCA, helping us out, getting this information out to everybody. We have a lot of topics. Is my basic point. We have 10 different subject matters, so we're going to go through them to make sure that we get through them all, and then we'll take your questions at the end, as Bob laid out. You can email them in or put them in chat. So the first topic that we want to cover is contractors should have discovered the conditions, right? So this is all relating to differing site conditions. And this is the typical site investigation clause, right? So generally speaking, this is an exculpatory clause, which is a fancy lawyer word for get out of jail free from the owner. It's saying, when I gave you the bid solicitation, I let you have the site to investigate it. You should be generally familiar with it, and therefore anything that you find down there is your problem. Generally speaking, it's enforceable. Okay, you got to check your state law, but generally speaking, it's enforceable if there's four things. One, it's got to be reasonable, right, with respect to time, access, and scope. I can't say, here's the bid, it's due tomorrow, and you can do a site investigation. The language has to be clear within the contract documents as to what you're able to do, making sure that you have a fair opportunity to conduct a site investigation. I had a case once where we had hazardous soil on the site, and even though we had plenty of time to go out there, this was in New Jersey. In New Jersey, you can't take contaminated soil to a site to dispose of it unless you have a contract. So really, there was no fair opportunity for a site investigation because no one could come out on a site with hazardous soil, take borings and take samples of the soil, and then do what with it? You'd have like 50 different contractors running around with a pile of contaminated soil in their trucks, right? And then you're going to have to also look to see whether or not the courts considered the site conditions were material to the contract performance, right? So it all has to line up. But with those things lining up, meaning it's reasonable, there's clear language, they give you an opportunity to come out there, and whatever you could have discovered is material to the contract performance, they are enforceable. And therefore, you have to be aware of it. And if any of these three things are not there, it's not reasonable, they're not giving you language, they're not giving you an opportunity to conduct a site investigation, you got to document it. Document it in pre-bid meetings, make sure it's in the meeting minutes, write to the engineer of record, and make sure that you're identifying that you really didn't have either time, access, scope, any of these things. Because if you don't, then you run victim of when you go out there and you find something that's differing in the site conditions, they're going to come back with a clear defense position of you should have encountered it and known about it at the time of the bid. So with that, I'm going to turn it over to Tom for our next issue.
Before I get to that, I wanted to add one point, Shawn. My experience is the site investigation clause, the site being spelled SITE, has been generally interpreted by the courts to require only a site SIGHT investigation. In other words, you're responsible to know of what you can see in terms of what's put in paper, soil borings, soils report, as well as what you can see above grade. But at least my experience is with regard to the below grade aspect, be it utility, foundation work, you don't have to conduct your own subgrade investigation unless the contract requires that. In fact, I've court cases generally say if the owner offers the right to conduct a below grade but doesn't require it, you're not required to exercise that right.
I would agree with everything you just said there, Tom. If your contract doesn't allow you the opportunity to conduct a subgrade investigation, then you're not going to be held to it. Yeah, that's right.
Let me turn to the second issue that I've got. No owner pre-bid subgrade investigation. You know, it seems too often that, at least my experience in talking to engineers, the owner engineer want to save money by either not conducting a subgrade investigation or doing one on a limited basis, which makes no sense at all. But, you know, being a member of ASCE, also, you know, that's what engineers say. So too often you have a job that while it involves below grade work, you don't have a subgrade investigation conducted by the owner. And what does that mean for you as a contractor? A couple of things. One, if you're bidding on a subgrade job or below grade utility job without any subgrade, site-specific subgrade investigation, as a matter of law, you're required to rely on your own previous experience. So if my previous experience in the area is that I've encountered cobbles, boulders, I should bid the job accordingly. If I haven't bid there or worked there previously, you're going to be held accountable to what is normal in terms of the subgrade conditions there, notwithstanding that you haven't worked there before. So if in this geographic area, past projects would indicate the existence of cobbles, boulders, then you're responsible for that. You know, the second thing that I wanted to offer is, even though there's not information provided by way of the owner with regard to the anticipated subgrade conditions, you can still have a claim for differing site conditions if the conditions that you encounter are different than what's normally encountered in this area. So again, if my experience as a contractor is that you normally encounter, or let's say this way, you normally do not encounter cobbles and boulders. I've worked there before, I haven't encountered those. If in fact then I encounter those during the work, I have a right to a differing site condition claim, notwithstanding that the owner didn't provide any information with regard to the anticipated soil conditions to be encountered. And that would arise under the typical differing site condition clause, the second part of it. If you encounter conditions that are different than what's anticipated for the work in this geographic area. That's what I got. Shawn?
Perfect. So the next subject we want to cover is when there is no differing site conditions clause, right? So just to throw out a definition, a differing site condition is provision in the contract that addresses the unexpected physical conditions, right? And there's type 1, which is there's some sort of latent condition that differs from what you were told in the documents, in the contract documents. And type 2, which is what Tom was just referring to, is when the physical conditions differ materially from what's ordinarily encountered. So that's type 1 and type 2. If you do not have a differing site conditions clause in your contract, it's really precluding you from that type 1 analysis, where I'm making a representation about what you should encounter. What you actually encounter is different than my representation. Oftentimes up here in New Jersey and New York and Pennsylvania, there are statutes in play that give you a type 2. So they've codified the common law type 2, which is you're just reasonably accountable for what's ordinarily accustomed to be finding. So with all those definitions and that understanding, what would I do if there was no differing site conditions clause in the contract? Well, then I'm going to look to whether or not the contract specifications are design specifications or performance specifications. Design meaning that they give you some sort of roadmap on exactly what to do and how to do it. And if they start to give you a roadmap on design on what to do and how to do it, then they're liable for those representations. Whereas if it's a performance, which is here's what the requirements and the end goals are, right? So you're going to pour concrete and it's going to be a certain PSI. Okay, that's probably a performance contract. A design contract would be one where they give you the concrete mixture, they give you the temperature ranges during pouring of the cement. They give you the methods by which a concrete will be made, and they're really then giving you really instructions on how to go and do it. And for those representations can be used against them if those representations turn out to be different from what you encounter. So again, you've got to look at this. If you don't have a differing site conditions clause, and I'll talk federally, by the way, in federal contract law, if I had two borings and one showed, and both borings, it showed, let's say, a water level that's deeper and not going to affect my work, then I can assume between those two boring points, the land is the same. But that's not always true if you don't have a differing site condition clause. In the federal aspect, it wouldn't be true. You would have a business risk to determine, well, in boring one, it showed a level, water level of X, and in boring Y, it showed a different, water level. I can't assume that the land between those 2 points are the same without a differing site conditions clause. Now, if you're doing state work, that can all change. It's subject to your state, and you're going to have to look at it. But those are the kind of things that I would look for to protect yourself when there is no specific DSC clause. Is it a design specification where I'm telling you how to do it, or is it a performance specification? And more often, it's a composite of both. So you have to be particular on what you're relying upon from them. Tom, with that's what I would do with no differing site conditions clause. And if you, anything for you, or you want to jump to the next one?
I was just going to add one thing. So part of the takeaway too is when you're bidding a job, anybody doing a utility work, you've got to be looking at, among other things, is there a differing site condition clause? Because a lot of courts around the country generally say if there isn't one, the risk of encountering differing site conditions is on the contractor. Having said that, one way, as Shawn said, to get around that is what he's talking about is the implied warranty of design. If it's the design specifies how I'm to do it, say it's an open cut, if all the particulars are set forth and I can't do it, or otherwise it's more expensive than as anticipated, I might be able to get paid under what's the common law created implied warranty of design, notwithstanding there's no DSC clause. What I wanted to offer is I've had success in the absence of a DSC clause characterizing it as extra work. I've had success with that in Iowa, and I just recently had success with that in a project in North Dakota. So that's some ways to address that issue if you don't have a DSC clause. Do you want to add anything more, Shawn, before I go into the next item?
No, I think you go into the next item.
Okay. Next item is owner disclaimed contractor's right to rely upon borings soils report, which, by the way, really gets me upset. It's like, so often, I'll start again. The owner gives you soil boring soils report for one reason alone, right? Rely upon it. It's not for bathroom reading. And yet, having provided you the information to rely on, it seems like it's more and more the case that engineers include language that purport to say either you can't rely upon the soils information, and it might disclaimer might be for information only. Owner doesn't warrant the accuracy of the soils information provided. All sorts of variations of the disclaimers. As a matter of law, courts increasingly around the country have held that such disclaimers are unenforceable under a simple proposition, which is, as I was just saying, recognizing that the owner is giving you that information to rely upon. And as part of reaching that conclusion that owners don't have a right to rely upon, or rather to enforce those disclaimers, courts have also focused on, to the extent that the engineer has relied upon that same information when they're designing the job, when giving an estimate of the cost of doing that work, If it's good enough for the engineer to rely upon it, it's only fair that the contractor should be able to rely upon it too. So the takeaway is one, if you've got disclaimers, you want to look in your jurisdiction where you're doing it, whether and to what extent courts have addressed that issue. Again, for Shawn or me, I've got cases collected around the country on that point. Secondly, even if that language, the disclaimers are enforceable, you've also got another good way to approach it, which is a type 2 differing site condition. If there's a differing site condition clause, even if the contract provided soils information, the borings report is disclaimed, that soils information is still no less the best information of what to anticipate for the work of the kind being performed in this geographic area. So I've been successful in numerous states when there are such disclaimers to provide the strategy to the contractor to offer to the owner, hey, look, even if I can't treat it as a type 1, i.e. Soils information that's provided as part of the contract, I still have a right to bring a type 2 differing site condition, the second part of the differing site condition clause, on the basis that that same soils information, while maybe disclaimed as part of the contract, still reflects the best evidence of what the soil conditions should have been anticipated. And to the extent that I encountered conditions that were different, I have a right to bring a type 2 differing site condition clause. And again, lots of success around that with the country. And all of this, I want to emphasize to those listening, the strategies that Shawn and I are imparting to you are those to cooperatively, fairly resolve the issues on the job site, not in the courtroom. So while you got lawyers talking to you, our approach, Shawn, as well as mine, is working behind the scenes to help you resolve your issues cooperatively, with you communicating directly rather than Shawn or I having to come out from behind the scenes.
Yeah.
All right.
I'll just add to that. I share your disdain for these exculpatory clauses that say, here's the boring reports, but you can't use them for the purposes of giving me a low bid, especially in public work where you're going to get the low bid. So I would recommend including contingencies in any contract. I would price it up. If they're going to give me that risk, then the risk should be worth the reward, which means if everything goes right, for my additional risk, I get additional money. That's always, I know, with an estimator, always tough because you're always looking for the low price. But I would take that risk into account because I'll tell you, while Tom is absolutely correct, the rule of thumb is if I gave you the information, you can rely upon it. And there's great federal law to that issue. I can tell you, for instance, in New Jersey, the Supreme Court of New Jersey has not spoken clearly on that issue. And I had a case that went to trial with the owner, a city, putting up page after page of disclaimer language to a jury. It's a hard thing to get over at trial. So then you have to take it, because if you don't knock it out of the box on a motion for summary judgment, and when your state might not be clear on it, if it's a state DOT or a state job or a municipal job, you're going to follow state law, then it may become an issue of fact for the jury to determine. And then you're going to be encountered with, someone who doesn't know your area of the world, and they're going to see these disclaimers, and it's a real risk. We thank God we were successful, but it caused me such consternation. I wanted to throw it up as a reminder. Anything else, Tom, or I'm going to jump on to our next.
Let me add one thing quickly. If I'm doing a private job, another way to protect myself is, as part of my bid, reflect that my bid is based upon XYZ subgrade conditions. And two, ensure then, if you can, that my bid is incorporated into the subcontract. You can, and actually you can do that in a public as well as a private, but it's easier doing a private, but as well as a public job. And I see, at least on the trenchless side, subcontractors regularly including language like that in their bids that are more often than not incorporated into the subcontract, which protects the subcontractor regardless of what the contract does or doesn't say with regard to differing site conditions.
Right. Okay, so jumping on to our next subject, which is lack of contractor written claim notice. So this is where you're going along in a job, things are happening, and you're not paying attention to the contract that says you're going to give me notice of anything that could potentially increase your claim for time or money within X number of days of the first occurrence, is usually the language. And these provisions, if clearly stated in the contract and reasonable in terms of timing and method, are enforceable. It's a notice provision. Typically, you're going to have to prove, if you want to use it as a defense, you're going to have to prove some sort of level of prejudice, meaning I, as the owner, could have done something different to either redesign something or to directed somebody else to accelerate their work such that your claim would have been nullified or less had you provided me the notice that's in the contract itself. And you'll see it also from subcontractor to GC. For example, if the GC has to notify the owner within 7 days and you as a sub identified on the 30th day, you can see what the GC might say, well, had you timely notified me, I would have told the owner and the owner could have paid. But because you didn't notify us on time, you're not going to be allowed to get that claim passed. Now, there's a case out there. It's an unpublished case, but I want to spend a minute talking about it because it was brought to my attention and Tom's actually in our legal committee, and it's CR Construction out of Washington. And the basic facts of this do not run in your favor as violating the notice provisions. It was a claim the GC took up about $360,000 of subcontractor claims, would go towards trial and win the sub its money and additional money for a total judgment of $1.288 million. Now, the owner took that on appeal. The owner said, hey, he never provided me with notice. But at trial, there was plenty of evidence that the owner had actual notice of the change in conditions. They were at coordination meetings, they were at other meetings on the project, and they were made aware of the change of conditions. But there wasn't a specific letter from the general contractor saying, hey, I'm going to make a claim and I'm within the time frame within my contract. And the court on appeal said, owner, you're right. Notice that specific work is occurring on the site is different from written notice of a claim to increase the contract sum. And therefore, it said our law in Washington's clear. An owner having actual notice of a change condition in the work is not an exception to compliance with the contractual obligations, and they overturned the jury decision. Why did they do that? They, in Washington, like some of the jurisdictions that I'm a member of the bar of, use an objective contract analysis, meaning they don't care what you think and what I think about the contract terms. They just look at the words on the page and they try to apply it. Now, I personally, I'll be interested, Tom, we haven't talked about in depth what you think about it, but I don't like this decision. I think if you have constructive knowledge that there's a change condition as the owner and you have constructive knowledge that it could increase the cost of performance, then you're held to that. And I think judges that just look for a rule that applies to every circumstance, like your contract said 5 days, you gave me notice on the 7th, you violated it, you can't recover $1.2 million. I think that's too far. I think they got it wrong. But I want you to be aware of this because when you're working in certain jurisdictions, your states might also apply this objective contract interpretation. Tom, what do you think about that? Am I right, wrong? What do you think?
Yeah, I mean, my experience around the country is, other than if I'm doing a federal project, courts have strictly construed the written notice requirement for a DSC claim. So for me, if folks listening didn't take anything out of our webinar today, it's that you have to provide written notice. And the fact that you verbally communicated the same information to the engineer based upon decisions around the country, it doesn't matter, other than on a federal project where courts are looking at just the opposite, which is, hey, if the owner knew by whatever means, that's sufficient. But outside of that, my experience is you have to have it in writing. And two, I think from a pragmatic standpoint, you should anyway, because putting that notice into writing makes it, I think, communicates it more powerfully than just talking about it verbally on the job site or the telephone. So.
Yeah. I would just add to that. I mean, I have overcome that issue recently in Pennsylvania, where we didn't comply with the notice, but because of the circumstances on the project and arguing that any written contract can be modified by the people's actions, we had sufficient understanding that we did get around the notice provision. But I mean, to me, I hear you, Tom. I think the prudent advice is comply with the notice provision, absolutely. But if you miss it by a little bit, I wouldn't give up on a claim. Also, I believe that, the circumstances do matter, that, it's not a catch me if you can scenario. A lot of, unsophisticated contractors who are doing big work might not understand that talking to somebody in a meeting minute or in a meeting, coordination meeting, and even if it makes it to the meeting minutes, isn't the same thing as writing a letter saying, I'm complying with section 6.3 of my contract. Here's my claim and here's my notice. But that's the best advice. I do agree with you on that.
Yeah. Which then leads me into the next topic, not stopping and work until engineer's DSC investigation is completed. Which is nice to talk about in the heels of Shawn's discussion on notice. My experience is more and more is that as much as owners and engineers talk about cooperating, the reality in the field is if you don't do exactly what the contract specifies, more often than not, the engineer is going to try and undermine your claim on the basis of that failure, which is to say, you've got to understand what the contract says and do what the contract says. And for a DSC claim, that means, first you give that written notice that Shawn's talking about. Secondly, you have to stop work in the area. And this is one that contractors mess up all the time because why? I don't have the cost of idle iron in my bid. So I'm certainly not going to sit around waiting for the engineer to make a decision because who knows how long it's going to take. Well, the problem with that is under the standard DSC clause, you're required to stop. So you either have to stop work or otherwise communicate with the engineer with regard to one, after you've given that notice in writing of a DSC, ask, can I continue working while you conduct your investigation? Because particularly for a lot of contracts, you have a right to get paid for waiting for the engineer to complete their investigation. I know, for example, under the standard DOT clause around the country, your right to get paid for delay is under the suspension of work clause. So although it's normally you're not have a suspension of work clause, the standard DOT clause, for example, says if the work is suspended or delayed for an unreasonable period of time. So I've had lots of success under most contracts, unless there's a no damages for delay clause. More often than not, you have a right to get paid waiting for the engineer to make a decision. And again, having said that, I think the better approach is to ask the engineer, and you have to ask the engineer. You can't ask the inspector because the inspector doesn't have the authority to change the terms of a contract. Only the engineer does. You ask the engineer, hey, look, I believe I've encountered different site conditions. Okay, per the standard clause that applies is I got to stop working until you investigate it. If I stop, the cost of this could be a lot higher. In order to minimize the cost, can I continue working while you conduct your investigation? If the engineer says no, okay, you got to stop work and do what the contract specifies. If the engineer says yes, make sure you immediately confirm that in writing. Hey, I just want to confirm my understanding, Shawn, the engineer. As you know, I've encountered, this is my initial written notice, I've encountered what I believe to be different site conditions. Although the contract clause, the DSC clause says I got to stop work per our conversation today, you've told me I can continue work during the pendency of your investigation in order to minimize the extra costs. And then the magic language at the end of it, if your understanding is different, notify me immediately in writing. Otherwise, I'll proceed on the basis of this understanding. Thank you. Look forward to cooperating on this. And again, that's got to be emailed. You can't have that in a note in your somewhere that you've kept. You've got to communicate that immediately. So that's really important, and that's how I would proceed to, or how I recommend to proceed with it.
Yeah, that dovetails nicely into our next topic, which is the engineer does not investigate the alleged different site condition, right? And just to kind of augment what Tom just said there, what I would do is one, document, right? So take photos, take videos, take notes, of everything that you're seeing down there. If he's not investigating, especially if the answer to Tom's request by the engineer to say, should I keep going to mitigate, what's going to happen here? And he says yes, right? So if you're doing trench work and you're going to bury the trench work, obviously take photos and videos of what's down there, what you've replaced, and what unknown conditions you're seeing down there. Notify the owner in writing formally about the DSC clause, the failure of the engineer to investigate, and reference your contract provisions on that. And then continue to follow the contract procedures on whatever it is for claims, ADR, both available options for you. Oftentimes we think, if an ADR provision, meaning alternative dispute resolution, if mediation is a condition precedent to litigation, we think in terms of, we'll finish the job, then go to mediation, then go to arbitration. You don't necessarily have to finish the job. Most contracts don't require you to finish the job before you can elicit mediation. In a situation where I think the engineer is not investigating the DSC clause, and there's going to therefore be, competing detailed records potentially, and issues around the fact that he hasn't done the investigation, I would, enact that clause early. Try to get the mediation as early as possible. So that's what I would do. Kind of dovetails into, do you stop work or don't you stop work? But once you get that, I also ask for what we call in this area either an NOD or CCD, Notice of Direction or Construction Change Directive. In the AIA complement of contracts, it's called a CCD. In a lot of public city work up here, it's called an NOD. But that's exactly the thing that Tom was talking about, which is direct me to do this work. I think there's a differing site condition. You're not investigating it. What do I do? Give me direction to go do it. And then you can argue that while we knew we didn't get to an agreement on the price, we absolutely knew that I was looking for additional costs and or time related to this event. Tom?
Yeah, I want to circle back to something you said that's really important. While the engineer under a typical DSC clause is required to investigate, determine is there a DSC, and if it is, what work items it's affecting, I recommend a standard operating procedure. If you believe you've encountered one as a contractor, you conduct your own investigation. So if I've got soil borings that show sand, class 5 size rock, and I encounter cobbles or boulders, because the difference between a cobbles and boulders and class 5 is a difference of size, I've got to make sure that I'm documenting the existence of cobbles and boulders. I'm going to take pictures, and I'm going to make sure that if I take pictures, for example, I've got a tape in order to indicate that it fits within the size of a cobble. Oh no, it's bigger than that. It's a boulder. Here's the measurement of size. 2, I'm going to make sure I'm saving that. 3, if I'm encountering a softer soil where on open cut work, I got to slope it back further, so I got to excavate more material than I anticipated. I figured, 2 to 1, I got to cut back 3 to 1, 4 to 1. I want to be, documenting what, not only that I have to do that, but the reason that I have to do that. So obviously that would be because the ground's softer than what I anticipated or what the soils and soil borings indicated. So, I'm a big fan of getting a geotechnical engineer out there to take soil borings to evaluate the strength, the characteristics of that soil. And similarly, if I encounter a higher groundwater table, you want to be documenting that, videotaping it, having a reference point to indicate the elevation of the groundwater actually encountered versus what the soil borings indicated. So, Shawn, I'm going to go on to the next one. I don't know if you want to add anything more.
No, good. I'm good. Thanks.
And my related point is, in order to cooperatively and fairly resolve the issue for a DSC on a job site, be in communication with the engineer. What does the engineer believe? What do you think? Do you believe, because you want to find out what do we agree on and try and build on that. Similarly, to identify what's in disagreement or what the engineer doesn't understand, to make sure that's what my efforts are focused on, to educate the engineer and to convince him of my position. Again, cooperatively on the job site, not later in a courtroom. All right. The next topic is proceeding with no written approved change order. And, again, too often that happens. And it's important to understand that your right to payment for a differing site condition can also be properly looked at as extra work. Because if I got to, whether I have to do work of a different kind or work in a larger quantity than what I anticipated, that's extra work. And so to maximize my right to get paid for it, as well as to get a corresponding time extension, I would look for a DSC to seek payment not only for it under the different site condition clause, but also for the extra work clause. And under literally every single extra work clause that you're going to run into, it's going to say that you do not have a right to get paid for what would otherwise be properly considered as extra work unless you get written acknowledgement from the engineer that it is extra work and it is compensable as such under the extra work clause. So if I want to get that written agreement from the engineer, though the reality is I'm normally not going to get it. And so if I'm not going to get it, I still want to preserve my right to proceed, notwithstanding the absence of the authorization for payment of that as extra work. And therefore, my recommendation to you as contractors is ask the engineer, hey, look, I know we don't have agreement on this, that it constitutes extra work. However, I want to proceed with the work. Can I do that with the understanding that I'm preserving my right to, address this issue later, i.e. whether it's extra work or not, notwithstanding that I'm proceeding without that authorization right now? Is that acceptable? Assuming that's acceptable, I'm going to document that. Again, any conversation that relates to cost, time, or constructability is one you're always going to want to document in writing before you proceed with the work. So again, it's a broken record here. You've got to, one, understand what the contract says in order to do what the contract says. And don't poo-poo that, because more often than not, even if you otherwise would be entitled to get paid for a different site condition, if you don't follow the procedure requirements of the contract, my experience is the engineer is going to, say you don't have a right to get paid. All right, Shawn?
Yeah, I'll just dovetail with what you just said to add from a different angle, right? From loss prevention, from that angle. Because oftentimes I get asked, well, you know what? I have a differing site condition clause. They haven't given me a PCO. They haven't approved my PCO into a change order. Do I have to do the work? And a lot of times on public jobs, I'm going to say the answer there is going to be collaborative with your surety. So let's not forget about your surety, right? On public jobs, if you're the prime, you've got a performance bond out there. And if you stop working, that owner is going to call the surety and ask the surety to come out and do work, meaning finish your contract before you pull the trigger. And this is a delicate conversation that you have to have with someone who's really, proficient in this area of the law and can explain it to the surety and their in-house counsel. But you have to have agreement, in my opinion, with your surety that if that bond gets called, that they're going to stand behind you and not go out and try to finish that work without you performing it. Otherwise, you're going to be fighting two battles at once. You're going to be looking to the owner to say, hey, I got an issue with you. And then you got your surety, who's also under the indemnity agreement with whatever principals of your company have signed that, is going to be looking to get reimbursed for any additional cost it takes to finish that job. You don't want to fight those two battles. So before you look at, hey, can I stop work, not do anything because they haven't given me a signed change order for this DSC, consider that aspect, because that loss prevention of not having to fight two battles at once is a game changer. So don't forget about that. So I'm going to, Tom, unless you have something to add, I'm going to jump on to my next topic, but I know I raised something new, so.
Because of time.
All right, Tom, I got you. So I'm going to jump on to engineer does not understand subgrade issues, why contractors should hire its own consultant. Tom kind of hit this already when talking about if the engineer doesn't do its site investigation, maybe you want to hire somebody else to go out there. Let me just reiterate or add that, that specialized consultant can provide an independent professional assessment of the actual site conditions. And that could be really persuasive to an owner. some owners think contractors are always looking for the change order, always looking for a way to increase the price. When you get somebody who's well renowned in the industry and in that area, and maybe with that specific state DOT, they can really add a lot of value. It's not the lawyer, it's the consultant that you're going to hire. It's the expert that you're going to hire who's going to come out there and give a professional assessment of the actual site conditions. They also might have different ideas on how to help document. We talked about how important that was, and to take pictures. And most importantly, I think that they have an expertise in claim presentation. You know, a picture's worth 1,000 words. While we can say, hey, this event happened, sometimes these consultants are very good at putting into graphics the things that lawyers struggle with pages and pages of narratives. So I think it's always a good idea, if you're having a subgrade issue, if your engineer doesn't understand subgrade issues, and the first indication of that would be he's not investigating the site when you tell him about it, get that expert analysis, but get the right expert. Get someone who's respected in your geographical area. Tom?
Yeah, but I'll add one more point. I am a big fan of, again, contractor hiring technical consultants. I just had a big DSC claim in Texas, and we got the owner to agree that it was a DSC. However, the owner argued that our extra costs were far too high on the basis that the owner alleged we failed to have the proper equipment, we failed to properly prosecute the work, and we hired 2 consultants. And again, I was working behind the scenes to address, why we had the right equipment, why we had the proper approach, and got a significant amount of money on the job site without having to fight for it later, otherwise having to write off a big chunk of change. So,
yeah, let me jump in there, Tom, because I had the opposite. I had a guy on a bridge project that went wrong, where we were working for PennDOT here in Pennsylvania, and their expert came in with an analysis of why it cost too much to fix this bridge that they had damaged in their efforts. And lo and behold, they weren't using prevailing wage. When you really got down to it, it was that simple. They hired an expert. So I said, get the right expert, right? Here's getting the wrong expert. They got an expert, went out and did an analysis of everything was happened. They didn't attack the hours or anything else because it was on a force account with PennDOT out there. I think that would have been hard to do. But the root problem with this expert's analysis is they changed the wage rate below the prevailing wage rate in Pennsylvania. And we got the expert thrown out, and then judgment as a matter of summary judgment. So get the right expert is critical.
Nice. All right, I'm going to address the last topic for today, no contractor proposal concerning redesigning work to avoid minimized DSC. I just had a project where it was a lift station and then a big sewer main, and there was no subgrade investigation done. And so the contractor bid it on the basis of its, historical practice in the area, which was dry clays. And when they got out there, they encountered wet silt. And so the job was going to be a lot higher. And what we recommended and what the owner did in response to the recommendation was to conduct a subgrade investigation in other parts of the project area to determine whether or not we could find the typical soils for that geographic area. The owner retained an engineer, went out there, and our client assisted, did some excavating. And in fact, between the contractor and the geotechnical engineer that was hired by the owner, they did find the typical dry clays rather than the wet silt that was in this area. We're able to redesign the project work to have it done at a different horizontal location as well as at a higher vertical location, and not only save the contractor all the costs of extra costs in doing the work in differing site conditions, but also, in fact, ended up getting a change order for an additional $200,000 because it was going to require more lineal foot of pipe in order to do the work. So, the owner was really happy as well because trying to install the pipe with that wet, silty soils is going to potentially compromise the requisite support for the pipe that was being placed. So, again, that it's a unique approach in order to avoid the extra cost of a DSC by way of seeing if the project limits allow for the work to be done at a different location in order to avoid the different site conditions. That's what I got.
Good points. Good points. All right. Well, those are the 10 issues that we wanted to go over. I don't know if anybody has any questions. I know we're a little bit longer than we thought we were going to be, Tom, but that's always how it goes, right? We always kind of go long. Bob, I don't know if you're with us, but are there any questions out there that we can answer for anyone quickly?
I'd be here till the very end. You guys are fascinating to listen to. If there are any questions, please go ahead and either write them in the chat feature, or if you prefer, unmute yourself, state your name and company, and ask the question directly. Remember to remute yourself after you finish.
The other thing I was going to add, I don't know if I'm showing up now, is Shawn and I will be addressing this topic more so at the annual convention at the Construction Law Committee meeting. So it's certainly another opportunity to discuss any questions that you have about this. It's just such a critical topic for anyone that does utility work. So the more you can learn about it, the more you can manage risk as well as minimize extra costs.
It looks like you answered everyone's question because there are none.
All right.
Can you hear me?
Oh, yes, we can. Please state your name.
Hey, this is Marty Kleinert with Environway Services Group, Southeast. What about if you have a natural disaster, such as what we've been encountering? What does that do to you for the contract?
So if you have a natural disaster, first place I would look to is the force majeure clause in your contract, and to see whether or not you're entitled to time or time and money. It's typically not a differing site conditions clause, although I guess the aftermath of the natural disaster, would be a differing site condition. But I would look to that force majeure clause that will talk about God and acts of weather and whether or not you're entitled to additional money. Now, oftentimes, force majeure will be limited to time and not money. So what you're going to have to say is that this new event in this time period, meaning the act of God, has dovetailed into a changed condition that, I'm entitled to more money. For instance, if a port got taken out and you couldn't get any material in, I'm just trying to think of something hypothetical, and that could increase the cost of expediting whatever material that you needed, or if in your region prices shoot up because of this act of God, that could be, in addition to time, a claim for money as well. Tom, what do you think about that?
Marty, I would be extremely confident that you could successfully seek and obtain money for that under both the differing site condition clause as well as the extra work clause. It's a natural disaster going to create conditions that were unanticipated. The natural disaster is going to necessarily create the need for additional work, both of which create the basis under the contract to get paid, be it the extra work clause as well as the differing site condition clause or the changes clause. But again, as I want to add one thing, as with everything that we're saying, you'd want to address that issue before you proceed with the work in the affected area. You raise the issue, because maybe the owner might say, well, knowing that now, maybe we should defer the work until later when it can be done, when the conditions are back to what was anticipated. More likely than not, that's not going to be the case, but at least having raised the issue, then the owner and the engineer have an opportunity to evaluate different options and therefore can, hopefully find, hey, we do want to have the work done now. And while it will cost more, we need that, the sewer, the sanitary, the storm, the water working properly. We don't have a right to wait. So, but again, have the conversation in order to allow options to be evaluated to maximize your chance to get what you want when you want and get it done cooperatively on the job site.
Yeah, there's a well said, better than I did. And there's a good point about notice, right? So if you put the owner on notice that this act of God has now potentially increased the price, as Tom just said, and I was alluding to, whether or not your force majeure contract provision takes over or it becomes a DSC issue, the owner could just suspend the job too. It could say, you know, I got enough going on. I'm just going to suspend the job for a period of time. Now, whether or not that raises, you know, an extra demobilization, remobilization cost, and extra work, I think that's what Tom was addressing. But, you know, they could really mitigate their damages by giving you time, extending it out to ride out whether or not they need this project done. Now, if the assumption that Tom made was true, which is it's an emergency, we need water and we need plumbing and we have to have your work done, well, then obviously now you might have a change condition.
And I would make sure
provision.
I'd make sure too, Marty, you know, so often a very real cost that's missed is delay, you know, i.e. iron sitting idle, you know, guys that might not be working, but are, you know, in the shop, you know, for a lot of people, you got to pay them or you lose them. Plus you have that, you know, very real care to make sure your people are getting paid. And so if the job is suspended or you otherwise are, you know, having to sit and wait or otherwise working at lower production rates, make sure that you're also tracking the equipment and labor that's not being used as well as when it is being used. And with regard to iron, normally the rate is the half the operator rate or Blue Book or, you know, industry standards. But again, another issue is to figure out how to price that work when it's not being used, i.e. it's sitting idle.
Great.
Are there any other questions? It appears not, gentlemen. Let's go and wrap this up. Tom and Shawn, thank you very much for your time today to lead this very important discussion. We'd also like to thank our many national partners for generously supporting NUCA and our monthly webinar series. Today's webinar has been recorded. A recording of this webinar will be made available on NUCA's YouTube channel over the next few days. And thank you for your time today to join us for this special NUCA webinar and for supporting NUCA. Thank you for your time this afternoon, and please enjoy the rest of your week.